Good morning to everybody on the West Coast. Good afternoon to people in New York, and good evening to our European friends. My name is Christina Kim. I am the head of marketing here at MarkVision, and thank you everybody for joining our webinar today. Before we begin, maybe we can go around and do some introductions. Mr. Abrahams, maybe you can kick us off.
Hi, good day everybody, wherever you are in the world. My name is Charlie Abrahams. I've been involved in this space, the online brand protection space, for longer than I care to remember, a couple of decades essentially. And these days, I am no longer working for a major brand protection company as I was 20 years ago, but I'm retired. I'm helping MarkVision, and I am commentating on the space and writing articles about it, as you will have seen on my LinkedIn profile and on the MarkVision website.
Yeah, and you're an amazing fisherman, as I have heard.
I'm a fisherman, let's put it that way.
Put that on your CV. Yes, and Sungbin, why don't you introduce yourself?
Hello, everyone. I'm Sungbin, the product manager for Marq Folio. My experience compared to probably Christina and Charlie falls short, but I've worked as a product manager for around 3 years now. I previously worked at a agri-tech startup, and now I'm here relatively new to the brand establishment and protection industry, but I'm super excited to contribute to this industry as well.
Yeah. Well, don't sell yourself short, Sungbin. You are phenomenal, and he's driven a lot of innovations for our trademarking product. And, that's actually a really great segue. Sungbin, this is a series around the basics of IP, and you are the PM for Marq Folio, our trademark management platform. Do you want to give sort of like a history, or sorry, not a history, but like explain what a trademark is, maybe to start?
A trademark is essentially anything that can be utilized to identify a product or a company. The most common types are word marks, logo, composite trademarks. But trademarks can be essentially anything. For example, the Darth Vader's iconic breathing sound in Star Wars is also a sound trademark. So,
Really?
yes, it's a fun fact.
I had
Did
no
you
idea.
know all the wrestlers in WWE, many of their moves are actually trademarked. I used to do a
No
lot of
way.
work with WWE,
Not know
and they
that.
trademark the moves, believe it or not.
So like it's literally called a trademark move.
Yeah, they do call them trademark moves, yeah, but they actually, the slam from the top rope or whatever you want to call it. Each of the wrestlers has some trademark moves, believe it or not.
Oh, and I'm
Really
sure it's like
interesting topic.
smell what the Rock is cooking or something like that is
That's
probably
right, yeah.
also something trademark. Everything is trademark. I'm the only person in the world that probably doesn't have a trademark. Well, that's really cool. And maybe like you can explain like a little bit about what Marq Folio does. Give your like elevator pitch, maybe, since you're the PM.
Okay, so Folio is an all-in-one trademark management solution that provides global registration, renewals, monitoring, and portfolio management. Now, but if you were to break down into more plain English, I guess just as the deed proves that you own a piece of land, a registered trademark is the official proof that you own that brand property. So we essentially help brands build the legal rights that let you earn and keep your revenue.
Nice. Great pitch. So Charlie, since you're the expert, I'm gonna pick on you a little bit. So Sungmin just gave an excellent breakdown of trademark. So I want to do like a lightning round of all the sort of like fundamentals
okay.
that like I think IP professionals toss around. So if you're ready,
I'll do my best.
All right. What's a Nice class?
So in 1957, there was a thing called the Nice Agreement that was created, and that basically has 45 different classes for trademarks. And that's important because if you take a word like polo, you want to be able to use that to describe, a type of sweets, so the little minty round sweets that Nestle own now. It used to be round trees. That would be under a food class, whereas Polo Ralph Lauren is obviously a polo. They can have the polo trademark and use it without conflicting with Nestle in a clothing class. So there's 45 different classes. And when you come to register a trademark, you apply to have it registered in a specific class as well as in specific geographies. So it's just a means of letting more than one person use a particular term or other item for trademarking something without it conflicting.
Right. A bonus point for having like the date for when it was actually like first. What's a word mark?
So wordmark is just an example of a trademark type. So polo in that example, Nike as in the firm Nike, whereas the swoosh would be a trademark that is a logo rather than a wordmark.
Okay, what's a patent?
So patent is a little bit more complex. So patents are granted to people who can prove and apply that they've invented something, be it a product or a process that is genuinely innovative and new. And you have to go through a relatively lengthy process and a little bit more costly process than registering a trademark to get a patent approved. And again, that may be geo-specific. So you would apply for a patent in the UK or in North America or whatever you were planning to sell that. But you have to be able to show real differentiation from anything else that's out there today.
Great. And what's a design right?
So a design right is more to do with the appearance of something. So if you had a shoe, for example, you could register the design, the color. You see a lot of that debated when we see supermarkets or people who are creating sort of own brand products. They often try to make them look as similar to famous products or not. So you see some battles between famous retail chains and boutique designers of clothing, for example, where they copy a dress, and the person who created that dress may have registered the design right, and they'll say, hey, this generic product that you as a retailer have put in your store and are selling for $50 is essentially the same as my item that I'm trying to charge several $1,000s for. So you sometimes see litigation around design rights then. But design rights can be a very useful way of trying to protect a brand where you haven't got the trademark or the patent approved within a country. So we do sometimes default to those when we're trying to protect a brand from counterfeit activity.
I only have 2 left, and then
Okay.
I'll let you get that. What is a copyright?
So copyright is perhaps the easiest to obtain. I mean, it's automatically granted to you when you create something. So when I write an article and publish it, it's automatically copyrighted. So if without my authority, you then cut and pasted some of that and put that on the MarkVision website, I could say, hey, that's a breach of my copyright. Obviously, I'm not doing that because I'm working with you. But this is very, very useful for us when we're protecting brands and we see listings where the image has clearly been stolen from a brand owner's website. So, for example, take the Nike shoe we're talking about. Let's imagine that somebody has some counterfeit trainers that they're using on a marketplace like eBay or Alibaba, and they've gone and taken the actual image that Nike was using on their website. Then if we can prove that, and we would use the technology that we have at MarkVision to prove that because of the image recognition and machine learning capabilities to find that stolen image, then you could immediately get that listing removed because it's a breach of copyright. Don't have to prove that it's a counterfeit item. Just in itself, that is a breach of copyright. Very easy to prove, and most jurisdictions recognize what's called the DMCA, the Digital Millennium Copyright Act, which allows you to enforce on a copyright. So copyright is really, really useful for us in the brand protection space. Any original piece of work or artwork or a song. There's a lot of stuff going on about AI and whether people are breaching copyright when they have something that creates a sound a little bit like a famous singer. That's going to be a huge ball of wax when we get into AI-produced music over the coming years.
I actually have something cool to show you later about that in this webinar. It's going to be a surprise. So I don't think you've seen it either, Sungbin. All right, and then last, what's a domain?
So a domain is the place where you put a website that is human readable. So a domain is just an easy way of finding an IP address. So obviously, if you want to have a website or any kind of place on the internet, you need to put it somewhere. And in the old days, this was just a long string of hexadecimal or numbers. Obviously, that's very difficult for human beings to use. So, www.google.com, that is a domain name. And that's very important that if you're thinking of launching a new product or creating a new brand, that you make sure that you can obtain the domain names in the places that you want to sell the product, because if you can't, you're going to have a battle on your hands, because it's very much about chronology. So if somebody has got that domain name already, then it might cost you a lot of money to try and buy that from them. So when we created one of the business I was involved in, we did a huge search on whether we could get the trademarks and the domain names for the name we were considering giving the business before we founded it. So very important to be able to get the domain names related to your brand in the places that you want to do business.
All right, Charlie, we'll take a deep sigh of relief. You're done, and 100%.
Thank you. Hopefully that was useful.
Thanks for entertaining my little basics of IP questionnaire. So let's transition a little bit into the IP landscape today. I mean, as you touched on, it's so different now, and there's just so many things. But if you had to sort of talk about any trends or risks that some companies face or faced back in your past that you think is worth bringing up, I'd love to hear your thoughts. Either of you.
I've got a couple of stories. Have you got anything first, Sungbin, you want to bring up?
Sure. I think in terms of trends, I think we can all agree that we're probably living in the era of e-commerce. I guess the sheer number of the different e-commerce platforms, the number of users and companies interacting is only rising. I think this also provides many benefits. Companies will find new opportunities and individuals will find the convenience. The rising problem is that it is becoming so easy for bad faith actors to simply reproduce one's original work and claim it as their own. In parallel, I guess, another trend is the rising number of trademark squatters. While the actual cost of filing a trademark in China will be only a couple of hundreds of dollars, taking back your trademark can cost up to an average of $150,000, which only highlights the importance of, I guess, proactively filing for your trademark. I guess another helpful mechanism that you can take is to sign up for a trademark watch or monitoring solution. So watch is an ongoing search solution that alerts you whenever someone applies to register a mark that is confusingly similar to your own. So most jurisdictions have a trademark publication period, which is a very short amount of time that opens the pending trademark for public opposition prior to the actual registration. So filing for an opposition during this period is once again so much more cost and time efficient than trying to invalidate a trademark that has already been registered. So out of all of the useful content we're providing today, if there's one thing that I can highlight, I think it would be the importance of filing for a trademark prior to the actual expansion date.
Yeah, I can't overemphasize that enough. So my two stories are, actually, well, before I got involved in this sector, I worked for a company called Plumtree Software, phenomenal company. I joined in 2000, and I was the first employee in Europe. They were a venture capital-backed company, which we took public. And they were really only operating in the States before I turned up. Well, some person who obviously made a living doing this spotted that Plumtree Software was an up-and-coming American company and registered the trademark of Plumtree Software in Europe before Plumtree thought of doing it themselves. So as soon as I started up the European business for Plumtree and we started to do some marketing, this person put their hand up and said, "Hey, we have the trademark. You're illegally using it in Europe, and we're going to sue you." And basically, they held us to ransom to pay them a large amount of money to get that trademark back. Because without that, every time we sent a piece of marketing collateral out, we were in breach of their trademark that they had proactively registered for Plumtree Software in Europe. So that was pretty serious. A more commonly known story that recently got resolved was we used to do some work for the iconic Spanish shoe brand Manolo Blahnik. They were made very famous in the TV show Sex and the City, where everybody was always talking about buying a pair of Blahniks. Well, I've met Mr. Manolo Blahnik, who's a fabulous guy, brilliant inventor of shoes and design, lots of design rights. But when he started his business, it was a relatively small company in Spain, and they didn't ever think they'd be doing business in China. So they didn't register the trademark Manolo Blahnik in China. And while we were working for them, continually counterfeit merchandise was appearing on Asian marketplaces, and it was impossible for us to enforce based upon trademark because somebody had done exactly to him what they'd done to Plumtree Software, and they owned that trademark in China. So we used to enforce based upon design rights, which Manolo had, and other tricks of the trade. But it made it just a much more cumbersome process. Well, they litigated for years and years. It took them 22 years.
Wow.
And as recently as a couple of years ago, they got that trademark back and now own it. And if you Google Manolo Blahnik trademark case, you'll see the whole history of that. But that must have cost them millions of dollars to recover. So as Sungbin says, if you take nothing away from this webinar than that, get your IP registered, trademarks, domains, design rights in the countries where you're going to do business. It's way cheaper to do that up front than after you've rocked up with a new product, an exciting brand in that place, because it then becomes a very valuable commodity to try and recover. So just a couple of war stories there that are really emphasize the need to do it proactively.
Yeah, exactly. I remember when I was at Google in the early 2000s as well, like I think squatting on domains just for generic names like happy.com or, shoes.com or something was a huge business, because not only could they sell it, but then they could run ads as like park domains on it or something. So
Yeah.
I remember the heyday of infringers back then was all about that. So, you guys have just, given warnings like, hey, you need to really, really treat IP as sort of this like jewel in your treasure chest when you're first going out into a new business or into a new venture. So I think it would be really great to sort of visualize it. So Sungbin, maybe, I think like a lot of people, when they think it's like, oh my gosh, it's trademark, it's IP, I need a lawyer, I need to do these things. But, actually at this step, it's fairly easy, I think. Maybe you can help just our webinar viewers visualize this by going through a live demonstration of how you would do it with today's technology.
Sure. Just give me a second. Are you able to see my screen?
Yes.
Okay, so this is essentially the page that our customers kind of walk through when they want to submit an application. So the first step would be selecting the type of IP. We kind of focus on trademark or design rights. But if you were to kind of look into the trademark section, there are different types of trademark types: word, logo, composite. As we discussed earlier on, there's sound and many more, but we typically focus on the word, logo, and composite. We typically advise customers or users to file for a word trademark because it provides the broadest level of the protection, regardless of any form, style, design, font, or color. So if this is my trademark, you then have to select the domain or the niche class that you want to protect your trademark in. It is important to note that you are only protected against the class that you register for, which is why it's super important for an accurate selection. I think this is the part where most of the customers or users have difficulty in selecting due to the domain knowledge. So we provide two options. They can either enter in their company website or provide a description of the product or service they intend to sell. Under the assumption that they know the specific class, let's say I want to sell coffee, you can simply select the coffee class, and then once you select the class, you're then prompted to select the country. Once again, some users already know where they want to be protected, and while some others don't. We also provide consultation on which countries you should file for, but under the assumption that the users know, let's say I want to file for in China and Indonesia. You can see on the right-hand side, we transparently show the pricing structure for how much it will cost to file for a trademark in China and Indonesia. And then once the users simply select the type of IP, the niche class, the country, and then enter in the basic information, this is basically it. After our IP consultation and IP consultation experts review the application, we will provide an heuristic eligibility report and then proceed on the actual filing for the trademark. So I don't think the process of filing for a trademark is complicated anymore, especially with the service that we provide.
That's amazing. And yeah, so it's such a great option to do in this day and age. And I love that you could actually have like an auto suggested thing for a niece class. I recommend that you also add WrestleMania move class to the thing. We should do like an April Fool's joke or something around one of them. Um, yeah, so obviously it's one of the most basic things to cover. And once somebody submits their trademark application, Sungbin, like what's sort of like the success rate, or like what target should they be looking for? Because right, like it might not always be the case where you get it approved, right? So what are some of like the average percentages that you've seen?
Our success rates can go up towards 90%, but I think the more important aspect is that for our consultation and experts, we value transparency. So if a user kind of says they want to file for a trademark under this name, we kind of disclose all of the risk and potential risk associated with that filing, which can result in a final office action, which is a rejection of the trademark application. While some traditional law firms and other services may simply just take the money and say, oh, we filed it, but too bad, it was rejected. We simply kind of disclose that risk and kind of also suggest this is the risk. Are you sure you want to proceed? If that is the case, we also provide a protection plan, which is a guaranteed refund of all service fees. We truly value what the customer wants.
Yeah, I think that was such a great idea. And our company is all about protecting original ideas and inventions and creativity. And the trademark is like your basic foundation. If you don't have that, you're not protected. So I love that part of the Marq Folio product. One of the things that I kind of wanted to show, and I know it's not trademark related, it's not anything related to what Sungbin just showed, but it's this really interesting trend. Have you guys seen the whole like Studio Ghibli like images? ChatGPT basically does this thing where you can have like a picture of yourself. Like I uploaded a picture of my family and my daughter's birthday to GPT, or actually my husband did, and it was just like a really really cute image of just like us being Ghiblified, and that trend was like set all around the world. And it's cool as a user because it's fun, but I imagine that it is a nightmare for the studio, right? And it's a nightmare also for like all of these content companies and potential brands. They're like, oh my gosh, they could actually use our style of an image and create something and commercialize it, right? And it's really interesting because there's no law around this, right? Copyright law, as I understand it, is that it needs to be the exact image, and that's where you can be like enforce on it, right? Like it has to be the exact fixed image that you're using for commercialization. But Ghibli is sort of this gray area. And so while the world is like waiting for this tech to, or waiting for the government to sort of catch up, I feel like tech is going to be playing more and more of a role along with platforms in enforcing this, because the rate of change that we're seeing is just unprecedented in any time in history. So I kind of wanted to show you something that our engineers just kind of spun up as a fun experiment when they saw, when they saw this phenomenon happening. So, I think it's not, like I said, there's nothing enforceable yet, but it's really interesting, right? Like when you have sort of this image, can we detect, that this image was Ghiblified? So one of my favorite memes of all time is Disaster Girl. And if you put that URL of that image here, this Ghibli style checker is able to see, well, was it Ghiblified or was it not, with near 100% accuracy? And you can see it now. So this is Disaster Girl in Ghibli form. I don't know if you guys like know this meme. And then it automatically says, yes, it's Ghibli style, confidence score near 100%, right?
Huh.
It's amazing. So let's do another one. Another one that I like is Skeptical Kid. Let's see, it was like something that I found on Facebook. Let's see if it'll do this Ghibli-style. Okay, Skeptical Kid, right? It says Ghibli-style. Yes, confidence score 99% again. So it's fascinating because it can actually pick out the styles, but is it just maybe it's just a cartoon image, right? Like maybe we can see like, well, maybe we can reference check like a cartoon image and see like, is it Ghibli style or not, right? And I picked a Japanese animation, One Piece, that my son is obsessed with these days. And let's see if it's also going to say if it's Ghibli style or not. No, it's not instantly with a confidence score of 95%, right? So it's really fascinating. The tech picks up. And this is where there's now a divergence of, I think like traditional tech, which is you train the software on a set of images and it has to be exact. But this is like a style, right? Like when you're a human, you're like, you see it when you know it when you see it, right? And it's like, oh, that's Ghibli style. This is not. And this is basically this like human inference that, generative AI can now do is like, yes, like we can know with, near 100% accuracy, it was a style. So I think it's really interesting, and that's just something that I wanted to show because laws are always going to be trying now to catch up. And in this day and age where IP, if it's your crown jewel and you need to protect it, you now have to think sort of creatively about like where technology is going and partnering with sort of not just the marketplaces, which is so important, and not just the regulators, which again is so important, but also the technology piece, which is that you kind of have to fight fire with fire, and that's just sort of the reality of today's technology landscape. What's really interesting is that Japan is now thinking of creating a law where they're going to outlaw these sort of like AI generated images. Because think about it, like Japan is the land of manga, of anime, of Pokemon, like all of these things. So, if people are going to commercialize on this and say, oh, we're going to have this sort of like same type of image style and we're going to make, a series out of it or something, right? They would be completely unprotected if they apply today's laws. So I think a lot of people are trying to scramble and think and make sense of what this means and how to protect businesses, how to protect these design owners. So I just thought that was really cool, and I wanted to show you guys.
That's clever.
Yeah, what we're cooking here in MarkVision every day. All right. So going back to Marq Folio a little bit, just curious, like I just said, like technology is this big piece and a big question mark as the landscape is changing. How do you think through how to apply that when you're creating, new products and features for Marq Folio? How do you think technology is changing the landscape of registration, and how is Folio different than, let's say, going through a traditional means?
Let's see. So I think opinions may differ, but I probably see the IP landscape, especially with the AI boom, as you said, to ultimately favor the brand owners. I think through the incorporation of AI detecting infringements in IP, whether it's in the early stages of IP registration or whether it's in the later stages of commerce, is becoming faster, cheaper, and more accurate. I also expect the rise of the importance in the management and protection of the digital assets or creative assets. See, as the world is becoming more digitized than ever, there's a rising need for a centralized system of storing and managing the organization's digital file. And I think the digital files or assets and IPs are closely intertwined, and I don't see the two separating anytime soon. And if you have been actively following us, you may have heard that we are in the active state of expanding our AI team, especially with onboarding of Reno, our head of AI. You might have already seen him in the past webinar. We're focusing on two values for our customers. So one, we're making every effort to make the trademark registration process less costly through automations and AI. And trademark registration requires lots of paperwork and manual work. And have begun the process of automating the entire process. In addition, we're focused on elevating the success rate of the registration. The single largest factor that causes the trademark rejection is due to the likelihood of confusion with the existing trademarks. Since it's nearly impossible to manually check for all potential risk cases, which is why we've not only connected the trademark database for more than 100 jurisdictions, but is actively working on a new AI algorithm to accurately identify potential conflict cases. And we've already are seeing some positive results, so I'm very excited for what's to come.
Oh, Sungbin, I feel like we need another webinar with you in a couple of months with a teaser like that. So get ready, everybody in Marq Folio, coming with some new features very soon. Just curious, are there any like stories of like any companies that have gotten some like really interesting value from using Folio in your experience? Anything you can share? You don't have to if there isn't any, but was just curious because Charlie gave a great example of Manolo Blahnik.
I think there's too many to select one, but
Mhm.
I guess while we serve all sizes, I think companies that have established some revenue in their home country looking towards global expansion will benefit from our service the most. So most companies find it difficult navigating the trademark process in foreign countries, where Folio is able to help. And it is best to preemptively register a trademark to prevent bad faith actors. But in case that it has been already squatted, we are here to help as well. For example, we recently had a Korean clothing company called Muramus as a customer. And as they were planning on expanding to the Chinese market and register in one of the Chinese e-commerce called Xiaohongshu, they realized that their company name trademark was squatted by the bad faith actors, which prevented them from registering. However, through our service, they were able to use our service and proceed with the invalidation process, which is the legal procedure to cancel a registered trademark, and was able to successfully reclaim what was rightfully theirs. So as trademark squatting is becoming more prevalent, once again, it only becomes increasingly more important to proactively protect your trademark and register before others. The time and the cost associated with retrieving one, assuming that it's even successful, is much more resource heavy. And in addition, if you were to account for the opportunity cost associated with the time that you're not able to sell, the risk simply only becomes higher.
Yeah, really beautifully put. And also, I think that we have a lot of K-beauty brands that use Marq Folio as a product, right? And K-beauty, I don't know if you are familiar with K-beauty brands and products, Charlie, but it's like the number one, or what was before the tariffs, like the number one imported like makeup and cosmetics category was from Korea. And so a lot of our brands would use, like Romand is one of the examples that I always give. I actually am like wearing one of their like lip colors right now. It's like really huge. It's everywhere globally, and they use Marq Folio to trademark anytime they expand, and they found huge success when they're licensing and doing new creative things. They're trademarking, and they've worked with the team to have an understanding of that. So really, really cool. Just seeing that, everybody thinks like, oh, when we're expanding to a new market or we're trying to grow our business, they automatically think like, what kind of ads should I put out there or something? But really, really, you should be thinking of trademarks as a first level. You should really be thinking about like, well, how am I protected in this market first?
Yeah, chronology is so important. Being the first person to own the IP is really one of the most important deciding factors when they look at any litigation in this space. So as the two examples I gave you, chronology is so important. Get the IP before you start demonstrating that you're going to have a business in that country, because otherwise somebody else will jump on it. And it's so much more expensive to try and reclaim it than it is to get it early. That's really the golden rule of this thing. Chronology is everything.
Exactly. Beautifully put. So, I think we only have maybe a couple minutes left, but kind of wanted to hear you guys opine on the future of IP and registration. I don't know, Charlie, like how do you see the IP landscape, it changing or maybe remaining the same in the next 3 to 5 years? Do you have any thoughts on that?
Yeah, AI just pushes the boundaries so much. I mean, we've seen these examples, as I said, the musical examples of people using AI to sample people's vocals or music style, and then create a new work, but one that is, you know, I think there was a case of one of Kanye West's pieces being, you know, him trying to litigate, you know, is that a breach of copyright if you're basically creating something that has come from their work but actually isn't their work? That's really, really niche litigation. We're going to start to see a lot of issues around that, and there's already been, you know, I think some of the Wall Street Journal, I think, is trying to sue one of the AI companies over having their content, their copyrighted content, crawled and used to feed AI technologies. So there's just going to be a whole new space around how AI intersects with intellectual property over the next couple of years. I really see a big trend in that direction for sure.
Sungbin, do you have any closing thoughts for the IP landscape, or, you know, how, you know, Marq Folio might be preparing for these changes? Any sort of look into the future from you?
I think it's more of a food for thought, but I think in the immediate or to a long-term future, there's going to be lots of debates and controversies across the physical world and the digital world. So there was a hype around the metaverse a couple of years ago, but if a shoe design has a design right on a shoe design, and if that same design is utilized in the digital world, should it be protected or should it not be protected? And I seem, because the laws are clearly not set yet, I think this is a industry or a field that will cause a lot of debate around. For sure.
Yeah, the metaverse. That's a very good point.
Yeah, both exciting and both sort of you know, throwing maybe the fast pace of AI might be throwing caution to the wind a little bit too. Well, great. Well, I think this was a really great discussion. Thank you guys so much. We're at time, but if anybody has any questions or comments for either Charlie or Sungbin, please email them to us. You can email them at marketing@markvision.com. And for anybody attending ICC or INTA, we will also be there. So we'll see you there next week as well. All right, you guys. Well, thank you so much
Great.
again.
Thank you.
Yes.
Thank you.
Great to see you both. Take care.